Hello, are you Mr. Kletke? Okay, this is People of the State of Michigan versus Alan Kletke, docket number 20-781FH. And this is the time set for the defendant's motion to modify bond. And Mr. Hess is here for Mr. Kletke. Mr. Kletke is also here. And Ms. Allen for the people. You can go ahead, Mr. Hess.
Thank you, Your Honor, and good morning. I'm here on behalf of Mr. Kletke. This case, I'm getting some feedback, Your Honor.
Oh, I'm not hearing it on this end.
Okay, all right, I'll just keep on going. Your Honor, this case arises out of some alleged violations of a PPO. There was some activity in the circuit court earlier this year, and then the prosecutor charged it as a felony stalking when there was a second alleged violation. Mr. Kletke was on bond and he was doing just fine. He had a new job arranged at the Lansing Country Club where he was going to start working. We held the preliminary examination. The district judge, Judge Allen, decided after hearing the testimony that he felt Mr. Kletke was a risk to the community and would not stay away from the protected person, so he raised his bond. Mr. Kletke's been in jail ever since. The situation really hasn't changed. He cannot afford to post any sort of bond. If released, he plans to live with his parents. He's able to help his mother out with her paper route for the State Journal. She pays him $20 every time he helps her out, which I believe is $5 days a week, so $100 a week. He does want to get work outside of the house. He has stable housing with his parents, and as I put in the motion, he doesn't really go anywhere besides Quality Dairy and Kroger. He does understand that the main concern, at least of the district court and presumably the circuit court, is that he has to stay away from these protected people during the pendency of this case and even afterwards because the PPO is still in effect. With the help of his mother, Ms. Struble, Mr. Kletke's been screened by JSG for an indigent tether. And I believe there was an email that went out from JSG. They're ready and able to fit him if the court orders him to have a tether. So what we're requesting, Your Honor, is for Mr. Kletke to be released on personal recognizance, but ordered to be fitted with a GPS tether through JSG, and that would serve basically as proof to show the court if he's complying with this order to stay away from the protected persons. It is a little bit awkward. He lives 1.4 miles away from them. That's pretty close, but not exactly next door. He's got no business being anywhere near their house. He's assured me that he would stay away from them. Of course, the proof is in the pudding, as they say. I don't believe from what's in the record, which was the preliminary examination transcript, that there's been any real allegation that Mr. Kletke has threatened anyone or shown weapons. There's just this allegation that he won't stay away from these people. And if we do have a trial in this case, the court will see that there's some family dynamics here, some strong emotions. All of this really has to get sorted out through the family court. It's unfortunate whenever these cases end up, in the criminal court, but we're dealing with it as best we can. But at this point, Your Honor, I do believe that the return of Mr. Kletke to court and the safety of the community as a whole could be assured through him being released on personal recognizance and by appropriate court rules to be in place. At this point, he's awaiting a trial date and who knows when that's going to take place, just with the current situation with the docket backing up as it is. So I would respectfully ask that the court release Mr. Kletke on personal recognizance. Thank you.
Ms. Allen?
Thank you, Your Honor. I'd have to disagree with Mr. Hess's recitation of the facts that came out the preliminary examination, because what was testified to is that the defendant repeatedly violated this personal protection orders, showing up at the victims' homes and threatening their lives. He told victim James Kane he was going to catch around, which Mr. Kane took as a direct threat on his life. And after the preliminary examination, the district court on its own raised this bond and added the GPS tether requirement that the defendant is requesting at this time. And we think that based on MCR 6.106, bond is appropriately set. The pretrial services investigator, we just got a report, it may have been this morning, recommending the defendant not be released on his personal recognizance based on the fact they could not verify the defendant's background with Ms. Strobel, and based on the serious nature within the offenses, they would not be recommending that release either. And the fact that there was a court order in place that the defendant has already shown he will not follow, and not just not follow by making contact, but going to these victims' homes repeatedly, recognizing there was a court order in place and purposely violating it and continuing to traumatize them while this case, while the PPO was in place, makes me think when they say he doesn't go very many places, the places he goes are these victims' home repeatedly. And I have concerns that a tether would prevent that from happening. And so based on MCR 6.106, I think the bond is appropriate, and we'd ask the court to deny the motion.
Having unconsented contact with someone in violation of a PPO or a no contact order of any kind is one thing. But in this case, the preliminary exam testimony was that the defendant had contacted these alleged victims so frequently and consistently that they only had a few weeks of quiet moments where they were not threatened and harassed. They testified that Mr. Kletke left threatening voicemails, came to their home in violation of a PPO, made explicit threats to one of their faces, telling Mr. Kane he could catch around, and even allegedly damaging their property. Even if the pre-trial services investigator could have verified more of the information, just in light of the preliminary exam testimony, I have the same reaction that the district judge had. I think that the bond set here is reasonable and appropriate for protection of the community, specifically the alleged victims. And I will not alter the bond or give the defendant a PR bond as requested. So the motion is denied.
Thank you,
Mr.
Your Honor.
Hess, you submit an order with your motion? I can't remember. I didn't see.
I don't think so.
I don't see one.
Okay. I can prepare one, Your Honor.
Okay, thank you. That'll conclude our hearing. Mr. Kletke, you can tell them they're at the jail that you're all set.